way of introduction. Good morning to all of you who have joined, and welcome to this, the fourth in our series of webinars for Climate Month 2025. As I said a moment ago, I will be introducing Gerard Forlin KC to speak about the steps being taken internationally and in the UK towards the establishment of a new crime, ecocide. As its name suggests, ecocide is concerned with the killing, from the Latin cedere, and eco from the Greek, the addition widely used to evoke the environment. But before I introduce Gerard, just a reminder about the other resources available from Cornerstone Climate. The slides and recordings from Climate Month 2024's 16 webinars are now freely available via our website. Do take a look. There's a Cornerstone Climate page on the website under Expertise, and a link to those slides and presentations under the heading Catch Up on the Climate Masterclass. This year we have built on those foundations to make the training as accessible as possible to as many as possible. We provide the webinars free of charge. Register for Climate Month 2025 and you have access to a wealth of training on climate-related legal issues, which are now, and increasingly, as many of you are aware, an essential part of a lawyer's toolkit across a wide range of disciplines. So just a brief word about what we've been doing in 2025 in terms of knowledge development and Climate Month. On the 3rd of September, Cornerstone barristers Rowan Clapp, Lois Lane and Max Millington provided an update on climate litigation in the UK. This is a must-see, a real pleasure to see such a readily digestible and authoritative assessment of the UK perspective. And from my own perspective, it's particularly interesting to see the consequences of the Finch case continue to play out. The case in which the Supreme Court held that greenhouse gas emissions, which it is known with certainty will occur when petroleum products are eventually used, are the indirect effects of the commercial extraction of oil, and must, therefore, unless judged not to be significant, must be assessed under the EIA regulations. So that was the 3rd of September. The following week, on the 10th of September, Cornerstone barristers Estelle DeHaan KC and Hannah Taylor reviewed the 2025 Climate Change Committee's progress report in their update on UK progress towards net zero, cutting through to the essential messages and key facts it is helpful to have at your fingertips. On the 15th of September, just last week now, Estelle was joined by Joey Chowdhury of the Centre for International Environmental Law, Dominica Leitane of Opportunity Green, and their analysis of the International Court of Justice's advisory opinion on states' climate obligations. It shines a welcome light on this much discussed new development. And today, of course, we have Gerard Forlin's update on the potential for a law prohibiting ecocide, about which I'll say nothing more just at this moment. 2 days' time, on Wednesday, 24th of September, online at 3 p.m. in the UK, we will hear from Nina Pindham, Dr. Maria Antonia Tigre of the Sabin Centre, Dr. Joanna Setzer of the LSE, and Gabriel Mantele of La Clima, which is the Latin American Climate Lawyers Initiative for Mobilizing Action, in the 5th webinar in the Global Litigation series, spearheaded by Cornerstone barrister Nina Pindham and co-hosted by Mishkonda Rea. This one is presented live from Columbia University and concerns the law of Brazil. Do check it out. You'll find on our website the other 4 fascinating webinars already delivered by lawyers working at the cutting edge of legal developments in Australia, that webinar recorded in March, India, recorded in April, Ireland in June, and South Africa in July. And then finally, for this Cornerstone month, Climate Month, on the 30th of April at 2 p.m, Cornerstone barristers Tara O'Leary and Jeremy Ogilvie Harris will be joined by Katie DeCore of Friends of the Earth to examine the extent of freedoms of speech and assembly and their restriction by injunctive remedies, public places protection orders, and other civil and criminal powers. So that gives you an indication of the depth and breadth of work, as I put it, knowledge development work being done by Cornerstone Climate. Turning to today, without any more ado, I'd like to introduce Gerard Forlin, King's Counsel. He gave the Ecocide webinar at Climate Month last year and is superbly well placed to report on progress with the various international initiatives to establish a crime. The reach of his practice across regulatory, commercial, and criminal jurisdictions, both in the UK and abroad, is genuinely phenomenal. I will say no more than this, as one expert in health and safety put it, and I quote, "When he speaks, shut up and listen." So I'm about to shut up and listen myself. If you have questions, however, do please put them in the Q&A at the bottom of your screen, not the chat, and we will endeavour to answer them at the end of this session. I'll be moderating them so as to answer any that can be readily dealt with in writing, and putting to Gerard at the end of the session any that come through and that we haven't managed to deal with in writing. Thank you very much. No more ado. Over to Gerard Forlin, King's Counsel.
Thanks very much, Harriet. Yeah, well, I would never say shut up to you, Harriet, or anybody else. So that wasn't my quote. And as they would say, I was properly brung up. But anyway, that's hugely interesting introduction, shows the vast wealth of talent, not me, by the way, in these chambers across this whole area. And this area is huge because actually I was trying to think about this. I mean, this really is the intersection between criminal work, civil work, environmental work, corporate governance work, product liability work, bribery and corruption work, and absolutely everything to do with corporate governance. And it's growing at an enormous pace. I mean, I did this probably about a year ago, which is terrifying. And I can't believe when I was preparing for this, how much has changed in that year. In September last year, I spoke on this at the IBA's conference in Mexico and been greatly honored to speak about this amongst other things in November in Toronto alongside Jojo Mehta, which I'm going to mention in a minute. And that panel is actually, as Harriet so eloquently introduced, basically the health and safety and environmental panel, because it's very difficult actually to separate environmental damage, if you think about everything from water pollution to mineral pollution, to etc., and safety. And there's a massive trend, and that's growing. And in fact, after the last speech I did in Mexico, I was interviewed, and it came out in quite a few journals. And I said, I think this will really, really pick up pace. I do think the Treaty of Rome, which I'll come to in a moment, will be amended to include ecocide. Let's put it this way, others disagreed with that. They didn't think it would pick up so much pace, and they didn't think it would ever become an amendment to the Treaty of Rome. Well, I don't know who's going to be right, but in the developments in the last less than 12 months, my money's on my bet, actually, and I think others would probably agree with that. But anyway, let's just go back to basics. So the first thing I wanted to say is, what is ecocide? Now, you're going to see some slides in a moment. Will, who's manning the slide deck, not the disco deck, but the slide deck. No disco songs, Will, just the slides. I'm actually going to be dwelling very, very little on these slides. I'm just going to touch on some of them, but I want to get into sort of the meat of the sandwich in relation to some of the bullet points, because there has been, for the reasons I've just explained, so much movement and speed of movement and depth of movement in the last 12 months. But before we get into a definition, what is ecocide, right? So as very eloquently put by Harriet, And I actually, thanks to my mum, passed ancient Greek O-level by the skin of my teeth. And I was really looking at it. And eos means community, but it can also mean home. Very difficult concept from the ancient Greeks, and as Harriet said, still used and applied today. And kadire, to kill. So you're killing your own home. But in a little bit of more detail, it's damage that involves very serious adverse changes to the environment, widespread, beyond just local areas, crossing state boundaries or affecting the entire ecosystem, long-term damage with lasting effects, and wanton or unlawful conduct, actions that are either against the law or committed with some degree of reckless disregard for the environmental consequences. And just later on in this slide deck, we'll get, I wouldn't say the accepted definition, but certainly one that most people would be pushing for the amendment to the, well, the fifth crime under the Treaty of Rome, war crime provisions. So that's the first thing. Now, turning to the first slide, you'll see I've just very briefly touched on it because we want to try and leave some questions, time for questions. The next thing I'm going to come back to in a little bit of detail. And the third thing, which is the proposed laws, I'm going to come back to in quite a lot of detail, because things have actually really started to rock and roll north of the border, where I'm born, in Scotland. And they've actually now into their first reading of a new proposed Ecocide Scottish Act. And I would like very, very briefly to look at this. Next thing, just turn the slides, Will, please. You see the International Criminal Court there. I'm not going to spend any time on the next two slides, but I am going to mention in just a little bit of detail quite an important development that happened on the 23rd of July of this year, when the court handed down their opinion on obligations of states in respect of climate change. I want to touch on and then if we switch over the next slide, please, Will. There's the international definition, one that's widely accepted. You can see it, unlawful or wanton acts. Some of the people on this webinar will remember that word, wanton, wanton driving, reckless driving, wanton disregard, committed with the knowledge that there is substantial likelihood of severe and either widespread or long-term damage to the environment being caused by those acts. That's the one that was drafted in 21 by an independent expert panel. There is the late Polly Higgins, who really started all this with Jojo Mehta, who I will be speaking with in Toronto on the 3rd of November of this year, God willing. If you just turn the slides a second, please. Again, I'm going to just touch on this to show you how fast things are moving. You'll see on that first slide, bullet point, Vanuatu, other Pacific Islands, Philippines, proposed recognition of an international crime amending the Rome Treaty, the Democratic Republic of Congo, Fiji, and others who are really on the front line of climate change because of flooding risks, which is just a question of, I'm afraid, to what extent and when rather than if. They're really, really pushing. I want to come back to that in a minute. The prosecutor, chief prosecutor, who I don't want to be, I know him, rather busy at the moment with other things going on, but he is very keen on pushing this forward to an amendment to the international law changes. Next slide, please. Well, the directive I'm going to come to in quite a lot of detail. Can you just turn over the next slide, please? I'm just trying to show you in the slide deck what's there. There's a plan, and you'll see at the bottom bullet point there, see penalties, page 54 et sec of that EU directive. Now, for everyone just to remember, a directive basically is a directive. It tells the states what they need to do, but it leaves them some degree of wriggle room on how they implement it and legislate it inside their own jurisdictions. And of course, this directive came out in March 24, and they put inside that a 2-year definition, limitation, guideline, whatever you want to call it. So things are really hotting up on that front as well. I want to have a quick look at that. Next slide, please. I want to look at 2 very specific jurisdictions. France was the first one in Europe to pass actually specific laws. Now, a délit, as I spend 4 months a year in France, is what we would describe really as a misdemeanor. It would be probably, it wouldn't be triable either way using our definitions, but of course it's a code Napoleonic situation rather than a common law situation. So it would be summary only, if I can put it back to basics, probably not triable either way, although it's very difficult to cross-fertilize these exact phrases. That is currently still going on. That was a dry cleaner that was then redeveloped, and they found 800 times the limits on the solvents when they actually came to redevelop that land. And people on this webinar will know an awful lot more than me about contaminated land. But the French don't mess about. And the French, you know, can I say, flying a little flag for France, they're very often on the vanguard of any legal issues. Now, ecocide here, but also they're probably the most advanced on psychosocial risk, stress, and criminalization of that anywhere in the world. They're really on the front foot on that as well. So they tend to really be avant-garde, using their expression, over many other countries. Next slide, please, is Belgium, I think. And you'll see that again, the French and the Belgians, and as you know, Belgium is split into French-speaking and Flemish-speaking, which is virtually Dutch, for lots of religious reasons, and also because of the Spanish settlement of that area of Europe, Netherlands and Belgium. But again, they're very ahead of the game. Next slide, please. Right, so I'm going to very briefly look at the English and Wales one. I'm going to look at a bit more depth now in the Scottish one. And then where are we next, please, Will, on the slides? And then I'm coming back to basics. Well, I'm going to look at all that, but you get these slides in a minute, and just turn that. I think it might be the last one, and then okay, that's it. All right, so I'll come back and cover virtually all of these, but I just wanted everyone to know that hasn't had a chance what they have or will get in due course. So it's only an aide-memoire, a signposting of what I'm going to deal with. Okay, so the first thing, all right, is where are we in terms of everybody else? Well, this is kind of amazing. There's 11 countries that have already passed ecocide legislation domestically. I'm picking France and Belgium, but it could be Ukraine, it could be Russia, it could be many other countries. And at the moment, 27 other countries are actually considering ecocide domestic legislation. So there's absolutely no doubt that this is on its way up or forward, or whatever way you want to look at it. As I was quoted in that global article. That's another reason why I think I'm going to be right. The latest that I get is Sardinia is just about to pass its own domestic ecocide laws. Ditto the Republic of Congo. So it really, really is a growing area. In talking about Congo, it was the first African nation to endorse the creation of an amendment to the Treaty of Rome and an international site. The Council of Europe, as long back as 2021, adopted a convention that enables states to prosecute environmental disasters, including ecocide. Vanuatu, as I've said, Philippines, want an amendment to the Treaty of Rome because they're right on the front lines, rising sea levels. As we speak, there is a massive super typhoon heading towards Philippines, Hong Kong, and China. And it's a super typhoon. I used to work in Hong Kong, and it would be a Typhoon 8. This is now a Typhoon 10. Typhoon meaning from the Chinese big wind. In June 25, there was a declaration from the 73rd meeting of COSAC. That's the Confederation of the Parliamentary Committee for Union Affairs of Parliaments of the European Union. I don't make this stuff up. And they're saying it's the first time they've acknowledged ecocide as a potential amendment to the Treaty of Rome. July 25, the Inter-American Court of Human Rights made public its advisory opinion on the climate emergency, including obligations to prevent irreversible harm to the environment, recognition of nature as a subject of its own rights. 2025 also, the African environmental ministers have formally agreed to include ecocide in Africa's environmental priorities for the next 2 years. The real driver, as I've said, has been the Democratic Republic of Congo because of all of the fauna and rich forests, etc., etc. And then that's that. Now, moving on, just to set this in some sort of context, I want to just very briefly turn to the Scottish, not because I'm born there, because I think Harriet's Scottish as well, but it's because they really are in this country the guys pushing it. So Monica Lennon, she was the one that's been really in the middle of all this for quite a few years. It's at stage 1, been given to the lead committee. It's very interesting. So it's defined by the Scots as causing severe environmental harm in such a way that is either reckless or intentional. Severe means environmental harm that has serious adverse effects and is either widespread or long-term. You can avoid conviction if you can demonstrate you didn't know about your employees' actions. Good luck on that, because that's really going against virtually all the other regulatory laws in this country and globally. All right, look at the new Fraud Act in this country, Bribery and Corruption Act, Corporate Manslaughter Act, and it's not just here, it's across the world. They couldn't have suspected the employee would have committed ecocide, and they've taken reasonable precautions. If convicted, individuals can be jailed up to 20 years and fined. All right, so that's where it is. Now, if you go into the meat of the sandwich, all right, so the bill, which I've got in front of me, as introduced, person commits an offence of ecocide, severe environmental harm, clause 1, intends to cause environmental harm, or is reckless. It's got to be so severe, it's either widespread and long-term. There is a defence of necessity. I can probably work that out. Clause 3, ecocide is committed by a relevant organisation, and the commission of ecocide involves consent or connivance on the part of a responsible individual. Now, consent and connivance is directly lifted from so much of the regulatory statute apparatus of the UK. Classic example is Section 37 of the Health and Safety at Work Act. So it says that the corporate commits the same offence if it was negligent, consented, or connived to it, i.e. if it wasn't taking adequate precautions, if the risk assessments weren't triggering properly, or if they did what's known in the trade as a Nelsonian eye. I don't want to know. I know nothing is not a defence, consent and connivance. The penalties, 20 years, up to unlimited fines, order for remediation and compensation, and that's often the really expensive stuff. And there's a publicity order as part of this. Now, again, I'm afraid that came directly probably from the Corporate Manslaughter Act, the Culpable Homicide and Corporate Manslaughter Act, basically saying that, you know, if you are convicted of this, you have to basically tell the world or your clients, depending on the size of the organization, how you're going to do it. So if you're a major oil and gas conglomerate, you might have to take it out in every paper in the world or something. So, and you have to set out the facts that the person had been convicted of ecocide, specify particulars. specify particulars of any sentence passed, blah, blah, blah. And that, again, is often the very damaging sort of part of that. Now, just don't want to leave the English out. Now, the English in 2003 have a draft bill, very similar, but slightly different. You can get a hold of it yourself. It's much more what I would call corporate driven rather than individual, aimed at individuals. So the purpose of this act, person, company, organization, partnership, or any other legal entity, so much tighter, registered in the UK, be in breach of Section 2, applies to an individual, meaning unlawful or wanton acts or omissions committed by a person of superior responsibility who had knowledge or should have had knowledge or should have had knowledge. So there's your Nelsonian eye, the commission or the omission. The commission to do something you shouldn't have done, or the omission to have done something you should have done. The Nelsonian I know nothing. Who had knowledge or should have had knowledge there was substantial likelihood of severe or either widespread long-term damage to the environment as it applies to a company, organization, partnership, or other legal entity, strict liability for unlawful or wanton acts and the omission. Sentencing, it's absolutely huge, you can imagine. So it's basically you can go to jail, lock away the key, proceeds of crime, etc., etc. Now that hasn't had the same appetite as south of the border, as north of the border, I should say, sorry. I'm not 100% sure why. I don't know whether the lobbying is more powerful south of the border. I don't know whether the fact that Scotland is more agricultural, obviously the oil and gas industry, and especially with President Trump's drill baby drill. I don't know where why the emphasis is much more on this than south of the border, but there you go. And in terms of the lobbying, I said of lobbying, it's very interesting. Just over the weekend, I found this article in terms of aviation. I do a lot of global aviation, and I'm going to be doing quite a lot more. And at the end of the day, this environmental article said the United Nations Aviation Organization, that's ICAO, by the way, is being captured by the industry, a report has concluded, leading to urgent action required to tackle the sector's high carbon emissions. This is a quote, industry delegates outnumbered climate experts by 14-1 at the recent Environmental Protection meeting of the United Nations International Civil Aviation Organization, ICAO, the report found. The ICAO is the forum where nations agree the rules governing international aviation. So, this article, whether it's right or wrong, was basically saying that the power of the lobbying industry of aviation, and I'm sure other sectors and industries, is such that it does have a normal effect. Now, I don't know the ways and wherefore of why Scotland is more advanced than England on this, but it clearly is. And since we're just mentioning this, and we haven't got time to touch today on greenwashing, but greenwashing and ecocide do go hand in hand. I mean, they are the same sort of issue. And as you probably know on this webinar, because if you're on it, probably quite interested, there's been a massive surge in legislation and enforcement around greenwashing, particularly in the aviation and what they call discard garment industry, whereby there has been a lot of enforcement recently around the world in those two sectors, but in many other sectors as well, including extractive industries. So, we couldn't really do this without even just giving 30 seconds to greenwashing. And there is definitely going to be much more work and enforcement in the greenwashing sector. Now, the next thing I wanted to really very briefly cover is just two things. How are we doing? 33. Okay, so on the 23rd of July of this year, there was published the obligations of states in respect of climate change. And it's an advisory opinion. Okay, so it's not binding, but it's an advisory opinion. And I've actually gone through it in great detail. And I just wanted to pick out just a few things for your notes. They talk about due diligence on page 50. A state is obliged to use all its means at disposal in order to avoid activities which take place or in an area under the jurisdiction causing significant damage to the environment. Page 52, common but differentiated responsibilities. The principle of common but differentiated responsibilities and respective capabilities reflects the needs to distribute equitably the burdens of the obligations with respect to climate change. Human rights, page 114. Under international law, human rights to a clean, healthy, and sustainable environment is essential for the employment of other human rights. So it's right up there. Cooperation, page 142. The duty of state to cooperate for the protection of the environment, and accountability at page 457. It's under obligation to make full and reparations for the damages caused by the internationally wrongful act, including providing assurances and guaranteed cessation of the wrongful actions and omissions, not emissions, and full reparation to the injured states. And in pages 130 to 131, very interesting, it actually sets out the unanimous advisory opinion. And we haven't got time to go through it. Trust me, I'm a lawyer. But it basically says, is of the opinion that climate change treaties, so forth, set forth binding obligations for state parties to ensure the protection of the climate system and other parts of the environment. And again, on unanimously, it said it is of the opinion that customary international law set forth obligations for states to ensure the protection of the climate system and other parts of the environment from anthropogenic greenhouse gas emissions, including the duty to prevent significant harm by acting with due diligence, and states have a duty to cooperate with each other in good faith to prevent significant harm in climate change. Now, very interesting. I actually looked at who was there for the UK, and it was no other than the Attorney General, the Right Honourable Lord Richard Hermer, KC, Her Majesty Attorney General for England and Wales. And interestingly, if you want to know, the judges, they were Tom Carr, Abraham, Youssef, Yu, Bandiri, Nolte, Charlesworth, Bryant, Gomez, Cleveland, Triad, and the registrar was Gautier. So it was very, very diverse in terms of geographical spread and nationalities and languages and legal systems inside that judgment. So that is, again, a big, big change. The other thing I just wanted to remind everybody was in the slide deck, the directive from March 24 with a 2-year guidance. I mean, it is kind of remarkable. I was really looking at it. You know, for those that want to know, page 54, the member state shall, it's a big word in law, shall take the necessary measures to ensure that criminal offences set out, you know, are punishable by a maximum term of imprisonment of at least 10 years if they cause any death. So that's lower than the Scottish stance, 20. Criminal offences, maximum term of at least 8 years. And then this is the sort of really major bit. And again, they said, member states at page 58 shall take the necessary measures to ensure that at least for legal persons held liable, they should be in proportion to the gravity of the conduct of the individual, financial and other circumstances. Member states shall take the necessary measures to ensure the maximum level of fines. For criminal offences, more serious ones, 5% of the world turnover of that legal person, either in the business year preceding that in which the offence was committed, or in a business year preceding that of the decision to impose the fine, or an amount corresponding to euros 40 million. 5% is a hell of a lot of a turnover of certain major conglomerates inside the EU. For the lesser offences, they say 3% of the worldwide turnover, and a fine corresponding to 24 million EU. So, I mean, that is pretty serious. And then, of course, aggravating circumstances at page 60, if you've got that inclination, and some very interesting wording and legislation around the limitation period. So they're saying under this directive, at least 10 years from the commission of a criminal offence punishable by a maximum term of at least 10 years, at least 5 years from a lesser offence. That's the limitation period. So you've got up to 10 years, because for those that really care, 62, page 62, Article 11, member states shall take the necessary measures to provide for limitation period enables the investigation, prosecution, trial, and adjudication of criminal offences sufficient time after the commission of these offences for those to be tackled efficiently. So again, massive changes since I last spoke about this. Now, just coming on to some other slightly ancillary points, but I think incredibly important. I just wanted to talk very briefly about a couple of cases which I think are fascinating and chime with the work I do globally in the regulatory field, right across a plethora of different industries, increasingly more and more aviation. But I've done virtually every single industry in my time. I just want to touch on two very small cases. Well, they were huge cases, but just two cases. The first one is the Supreme Court's ruling in Vendetta, all right, in relation to a parent company. And in a nutshell, about 2,000 Zambian villagers took action against Vendetta, which is a huge British FTSE 100 mining company, and its Zambian subsidiary KCM. And all fell down to what was known as the proper forum conveniens, which is the proper forum for litigation. And of course, it was argued, well, everything's down there. The witnesses are down there, the mine's down there, the physical evidence down there, documents are down there, so it should be there. And the Supreme Court, they said, yeah, but no, actually, because they said that, and it was, I mean, just my humble opinion, but it's very clearly, it was very important to them, and it's actually becoming more and more the same issue. They said that, firstly, the claimants were living in poverty and could not obtain legal aid and would be prohibited from entering into conditional fee agreements under Zambian law. Secondly, the claimants would be unable to procure the services of a legal team in Zambia with sufficient experience to effectively manage litigation on the scale and complexity. And that was one of the main reasons why they said, no, that is not, they struck out the application to say that the forum conveniens was clearly Zambia, not United Kingdom. This has been followed up by a large number of other cases. Here's another one, Okpadi against the Royal Dutch Shell PLC. This again, same sort of issue about proper forum conveniens against subsidiaries and parent companies. 40,000 citizens of two affected areas inside Nigeria in the English courts against Royal Dutch and one of the subsidiaries of Royal Dutch, the Shell Petroleum Development Company of Nigeria. They said that the spoils and spills and pollution from pipelines had done a lot of damage, etc., affecting drinking, fishing, agriculture, washing. Cut a long story short, again, the Supreme Court knocked that out and said, no, that was too narrow an issue, just dealing with the forum conveniens and the fact that there was a subsidiary and parent situation. And they came up with a huge amount, it's a really important judgment, huge amount of new jurisprudence. But I'll come back to that in a minute. And they actually said there is no presumption against parent liability. They said the Court of Appeal had erred in approaching the issue of parent liability and negligence with a generalized presumption that a parent company will be not liable for the acts of subsidiaries Following Vendetta, which is what I've just mentioned, the Supreme Court confirmed there was no such presumption. And this actually is what I'm finding in the work I'm doing, massive swing towards parent companies being liable globally for their subsidiaries across huge amounts of areas: bribery, fraud, corruption, safety, etc., just name a few. And this swing inside the UK is actually part of the same swing across other jurisdictions I've seen. Now, for example, in Canada and New Zealand, the courts have recently gone further, and they have been willing to hold parent companies liable for breaches of customary international law with respect to damages caused by their subsidiaries. So basically, this piercing the corporate veil and saying, yeah, we don't really care about the documents in terms of what you're calling it. We're actually looking at what the reality on the ground was and who was actually in control. And it's more and more the parent company in Canada, New Zealand, UK, Holland, and other jurisdictions. And again, I don't want to repeat it, but this is not just about ecocide and environmental damage cases and water pollution cases or oil and gas spillages. It's across all kinds of regulatory, global enforcement and corporate governance issues. All right, so that's just something. Now, very briefly, I want to just touch on Client Earth against Shell. Now, it's from 2023. We haven't got time to go into all the details. What I would do is recommend that you read, if you can, and call me or call Harriet, who will probably know more about this than me anyway, actually, Lord Robert Carworth from the ex-Supreme Court. His opinion set out in the London School of Economics Grantham Research Institute on Climate Change and the Environment. And he does quite a detailed and interesting, let's just be neutral, interesting analysis on why he thinks this case was decided differently, or it needed to be explored in greater detail. This was all around the issue of a derivative action brought by shareholders on behalf of the company Client Earth. They own some shares, and Client Earth derivative action argued that the Shell's board had breached the Companies Act, the directors' duties and under the Companies Act. I'll come to that in a minute. Which requires company directors to act in a way that they consider would best promote the success for the company for the benefits of membership as a whole. Client Earth's case was at the core, had failed to put into effect proper policies reasonably capable of achieving its stated objective to become a net zero business by 2050, resulting in a breach of the duties of reasonable care, skill, and diligence under Section 174 of the Companies Act. And the judge, the ex-judge, he sets it all out. Just so you know, 172 of the Companies Act says a director of a company must act in a way he considers in good faith would be the most likely to promote the success of the company for the benefit of its members of a whole. And the impact on 1721D, the impact of the company's operations on the community and the environment. 174 sets out the duty of a company director to exercise reasonable care, skill, and diligence. And again, they were saying that that hadn't been done by the board. Look, I mean, I'm not in any way trying to paraphrase Lord Carnworth's excellent article, but basically he said that the dismissal at that stage of the proceedings without a trial of the challenges of the actual evidence of the trials adopted missed, quote, opportunity because it would have provided a valuable chance to examine the operation of the relevant Companies Act provisions. The judge basically concluded that the Client Earth's witness evidence did not amount to expert evidence and other reasons, and actually, if my memory serves me right, actually imposed costs, if I remember, but I may be
wrong about that. But actually, if you want to know the citation, I'm sure you all know, it's Klein Earth against the Shell Board of Directors. It's 2023 EWHC 1897 Chancery, because it's under the Companies Act. So I just wanted to mention that. And just sort of, I don't know where we're up to. Careful, because we want to leave a little bit of time, because we can just scratch the surface here. I just want to look at some other sort of really practical issues that I'm also seeing. And I want to talk to you about a case from a few years ago, which I think is again part of a shifting change in corporate governance by global courts. This was an English case, but in a nutshell, an American chemical giant unfortunately killed two of their workers in a plant in California from the inhalation of nasty gases and chemicals. And quite a few years later, there was, please notice my thing, similar, wasn't similar, but I'm just trying to, in inverted commas, it wasn't similar, but it was different. But also had the unfortunate circumstance of having two other men killed on a plant which was a subsidiary of the UK, subsidiary UK of the American parent. And to cut a long story short, the High Court judge found that this was, he put it, an aggravating factor in the sentencing inside of the UK company in England in relation to the matter that they were being prosecuted for, and said that, this was something that sort of root and branch, paraphrasing it, should have been re-looked at across the entire operation of this global petrochemical company. And the fact they hadn't done that, and the fact that there was an incident inside the UK of the subsidiary of the parent, he felt was clearly an aggravating factor. Now, there was an appeal to the Court of Appeal on that, but leave was refused by the Court of Appeal. So again, it's just an indication in a small way, firstly, of the exact overlap between environmental issues, safety issues, product liability issues, corporate governance issues, often bribery and corruption issues, etc., company law issues, and the fact that there is a greater push now for parent companies to literally pay the consequences and deal with the consequences of the subsidiaries wherever they are. And this just follows, for example, the UK Bribery Act, saying that a parent company is responsible for a subsidiary in making sure that their systems are robust enough and their risk assessments robust enough and their reporting procedures are robust enough that they need to know what's going on across their operation globally. So again, that's just a small example. Now, I'm only warming up, all right, but I'm very conscious that we've got a lot of people potentially on that may or may not want to ask various things. It's just a gentle canter across the slides, which you'll see I haven't actually hardly dealt with at all. The slide on the International Criminal Court sets out what it is, but I've just given you a little bit more detail into the advisory opinion of July of this year. And so things are moving at enormous pace. And to final say, I think I'm going to be the one that's right on this. I think there will be an amendment to the Treaty of Rome. I think there's a huge push for it. And I think it's going to happen a lot faster than people think. And I think the direction is definitely going the way that I predicted it would 12 months ago in this international article, and maybe why I've been asked to speak again in Toronto with Jojo Mehta. But I'll just end there, Harriet, because it's just I'm just warming up, and I don't want to get carried away. But there you go.
Thank you Thank you very, very much, Gerard. An absolutely fascinating um, uh, sort of review of where we're at and how much has changed. If I can just run through just a few points to bring it together, you really emphasize how much has changed in the last year. You take us through the international definition of ecocide and how the climate might find its place within it. You tell us about the domestic legislation passed in other countries and there's many others, 11 other countries already passed, 27 considering. And takes all the way back to 2003 to a draft English bill, which is particularly interesting. You draw attention to the connection with greenwashing, which I found very interesting and helpful, and also how the International Court of Justice's advisory opinion and the new EU directive help, as it were, complement the information you've brought on the development of ecocide legislation. Really a broad-ranging and very helpful talk. You ended with those cases brought from Zambia and Nigeria. As for the Shell case, yes, I am I do have some passing familiarity with that case, and indeed Lord Carnwath's report on it, and would like to offer, and as I'm sure you would, if anyone wishes to read that, just let us know. We can send you a copy of Lord Carnwath's opinion. So it just falls to me to check the Q&A. There is a question, and I had a question. So if we can just spend a couple of minutes on this. We've had a question asking how the introduction of a new ecocide law in England would improve environmental protection over and above the proper enforcement of existing legislation. We have the environmental damage regulations, environmental permitting regulations, habitats regulations, and so forth. Would you like to just have a look at or summarize how a new ecocide law might add to the tools in the enforcer's box?
I mean, it's a fantastic question, and I'll be very blunt. There isn't a magic answer that I can just whip up. But all I would say is that I think, a bit like the corporate manslaughter legislation, there were many arguments, and in fact, I was very honoured to be the advisor to the General Counsel of the Bar on that act when it was going through. There'd been a lot of talk and quite a little action, actually, many years on that. And there was an argument about, well, what's it going to do? Why is it going to be better than the Health and Safety at Work Act and the Environment Protection Act and all of the other regulatory legislation? And there was an argument there. And I think the bottom line was, and I think I said this at the time, whether I'm right or not, is that it actually, the title, Corporate Manslaughter, Culpable Homicide Act, Ecocide Act, may or may not really grasp the minds and everything else of major conglomerates and all kinds of people, because to go down for a corporate manslaughter act or an ecocide act, I think would have a much bigger shaking effect globally for that organization. Plus, to answer without trying to be a clever lawyer, none of the other legislation that I'm aware of, but please correct me if I'm wrong, they don't introduce the publicity order stuff, which I'm afraid to say I think was, well, rightly, taken from by the Scottish, because you mentioned the English, the questioner, but I'm sort of talking on a UK basis, because the English was 2003 draft bill. The Scottish one is right up to date, 2025. Bill 23 was the English, 25 is the Scottish. And they talk about much higher sentences than are available under those other domestic previous legislations, and also it's put in one place, because one of the arguments is that it's very diverse in terms of it's spread all over the place. And that's one of the arguments the Scottish put forward for their introduction. They said the fisheries, and then the agriculture, and then there's this and there's that. And the fauna and the soil and the water, they think it should all be put in one place. And they have the benefit, notice what I'm doing in my hands, inverted commas, of the publicity order, which they, as the corporate manslaughter drafters said, would grab the attention of the derivative shareholders, the market, chimes with the greenwashing issue, as Harriet so eloquently just reminded me of. So I think that's my answer. I'm not saying it's perfect. I don't think there is a perfect answer, but it's definitely how can I put it? Pulling together in one place of a lot of disparate legislation, fauna, fishery, soil, everything, and bigger sentences, and a bigger title, and the publicity order legislation.
And when it comes, Gerard, just building on what you've said, and with the opportunity to think while you've been speaking, there's also the point, isn't there, that if we're thinking about climate change as the harm that is built into an ecocide crime, it doesn't matter where, unlike the current legislation that is England based, the harm could be anywhere in the world for the individual or the corporation, or indeed the public body, to be guilty.
Absolutely right. Just like the Bribery Act, that's a very good point. It doesn't matter where the bribery alleged took place, the trial could take place in the United Kingdom. Yeah, absolutely excellent point. And you see that's the direction travel with the parent and subsidiary litigation at the Supreme Court in this country and Canada and New Zealand and other countries. So it's a very good point. Yeah, well done. Thank you.
So thank you very much indeed for that question. And one from me, if I may, Gerard, just to round things up. Obviously, as a criminal offence, and I am a very long way from being a criminal specialist, in contrast to yourself, but as a criminal offence, could you say something about the standard of proof and the challenges that might arise for those seeking to enforce a climate change ecocide offence to the criminal standard?
Very difficult question. Very good question. You'll notice, actually, Harriet, when I was cantering through, because I had to canter through at quite high speed, you'll notice the word strict liability I mentioned. And we've seen this, you and I and many on this call, across a number of different areas of regulatory work, particularly in the environmental sector, but also in other sectors. So that's the first point. So there could be a strict liability issue. And secondly, yes, it's going to be very difficult, because you have to remember, as we touched on France and Belgium with the Code Napoleonic situation, it's going to be very interesting, because I do a lot of inquest work, as people might know, and at the end of the day, that comes from the Norman French. So from the French word enquête. So you're actually inquiring into what happened, rather than the common law jurisdiction we have in everything else inside the UK and Canada and Australia, etc., where it's the evidence that matters. So we were taught the first time we were barristers, baby barristers, we were taught we don't care what the truth is, what's the evidence, right? And inquests we got from the French, the Code Napoleonic system. It's the only exception in our jurisdiction, Harriet, both in north and south of the border, where you're actually looking at the truth, what happened, right? So you're going to have all these kinds of issues as well, depending on where these cases will be prosecuted. And I'm talking more globally now rather than just the UK, because as you said, 11 countries have already passed ecocide legislation, 27 are actively considering it, including Sardinia, who's one I mentioned, which I found very interesting, because that's a locale inside Italy, all right, from the old city-states of Italy. So that's been around tourism. And you've seen all of the, let's just be neutral about it, the factual situation amongst the tourists in Spain in the last 2 years. Again, that's an ecological, localized standpoint. So yeah, fascinating question. And it's going to throw up lots of different, but I am 100% sure, and I don't say that, but I'm 99% sure that we will definitely get an amendment to the Treaty of Rome. I think it's going to come a hell of a lot faster than people think it is. And I do think this is going to become, alongside the Bribery Act, alongside the Corporate Manslaughter Act, alongside all the product liability issues, a new weapon in the hands of the prosecutors globally.
Well, on that powerful note, Gerard, thank you very much for your presentation.
Thank you, Harriet, for sharing.
For all of you who've attended, and perhaps we'll see you on Wednesday, the 24th, at the next of Cornerstone Climate Month's webinars from Brazil. All the very best, and thank you.